Well, there are several things that keep me up at night with regard to clients, but at the top of the list, I would say, are those that have the biggest risks for the client. So there are things like class action and collective action exposure, and also the prospect that the assets of the business, which are the employees and trade secrets, will walk out the door with the employer not having the right things in place to enable it to address that problem. Well, wage and hour actions, when brought as a class action or a collective action, can have enormous exposure for any business, and the reason is because of the multiplier effect. And that's one thing that some clients don't really understand, that they tend to think it's somebody else's problem, but the fact is if you have employees, you have some potential exposure. What a class or collective action enables employees and plaintiffs' lawyers to do is to take the claim of one or two people and effectively multiply it by tens, hundreds, or even thousands of employees, which obviously exponentially increases the risk to the employer. And then on top of that, many of the statutes provide for multiple damages and longer than usual statute of limitations period. So the period of exposure and the amount of money at risk is much greater than it would ordinarily be, and then that's multiplied by hundreds or thousands of employees. Virtually any phase of the employment life cycle is exposed to a potential discrimination claim that arises in the context of an assertion of what's called systemic discrimination. And the notion there is the company may not be intentionally discriminating against anyone, but that it has a practice in place which has the effect of discriminating against a group of people. The EEOC has been very explicit that it has a heightened interest in so-called systemic discrimination and looking at those situations, and they are by their nature almost invariably situations that apply to broad ranges of employees or potential employees, even applicants for jobs, and therefore the numbers can be very substantial. I think there are two principal mistakes that companies make with respect to failing to protect adequately its intellectual capital and its trade secrets. One is with respect to agreements and protection that make very explicit what information is important to the company and that the information cannot be shared or used or disclosed except in the course of the company's business in an appropriate way. But the other thing that happens is that even if you have those agreements, courts will not protect a company who later complains that somebody's violated the agreement if, in fact, the company has not been extremely diligent about taking reasonable steps to protect its own information. Certainly, companies such as technology companies and pharma companies and the like are most at risk with respect to trade secret protection and intellectual property protection. But to be sure, any business has intellectual capital or relationships that it wants to protect. So even a retail business that has certain kinds of sales relationships and customer relationships that it wants to protect, values those, typically wants to have agreements in place, whether they're non-competes or non-solicit agreements that help to protect those relationships so that they can't just have someone walk off with them in effect. And those companies sometimes are not as sensitive to protecting that information as they should be, except maybe when it's too late and they're faced with a problem.